Thank you very much, dear Dr. Schindler, also for this very extensive introduction. It's perhaps also a testimony that I'm quite old nowadays, that I have a long track record. Thank you very much. I would also like to thank the Friedrich Ebert Foundation, namely Mr. Müller-Hennig and Mrs. Sofia Koller from CEP, for all of your research and the publications during the last years, actually. They resonate quite well in my ministry, and I can assure you this is always a very steady resource for us. So thanks much for having me. Also, thank you, Sofia, that you put me through the slides. Could you please go to the next slide already? I have prepared some program for you. I will touch upon very briefly on some FTF figures, giving some background also on the IDP camp. I saw in the list of the participants that we have some colleagues here in the virtual room, which are now based in Baghdad. Perhaps you know ways better because I touch upon the knowledge I have from my time in Baghdad. And then I come to the masterpiece of my presentation. I will touch upon the legal framework in Germany, because all what we are doing in the prison system is, of course, grounded in our legal framework. I will then report from the practical work in prison, so how we actually deal and treat with foreign terrorist fighters in our institutions. I will also have a little outlook then, and I look very much forward having later then the question and answer panel. The next slide, please. So here you see actually the map of Syria and Iraq, and all of you know that the IS-controlled area shrunk from January 2015 until May 2019. The US-led international coalition was actually formed to degrade and destroy IS in October 2014. And by the end of 2017, the combined joint task force, the Operation Inherent Resolve, has reported to have killed 80,000 IS fighters with airstrikes and other military operations. 3.5 billion were spent in military equipment to the Iraqi armed forces. Billions were spent to the Peshmerga, and 190,000 Iraqi soldiers and police officers were trained. And we also know that significant support was given to the Syrian Democratic Forces. IS faded away, but the people, of course, they remained. The next slide, please. Here you see an aerial picture of the notorious Al-Hol camp. This camp was established in 2014, and it was reopened in 2020, actually, 2019. 53,800 internal displaced persons were actually accommodated in this camp. There are extreme dire conditions in this camp. Now there are estimated 26,000 Iraqi and Syrian nationals, but also, of course, third country nationals accommodated in this camp. Many different organizations have reported that the conditions in this camp are life-threatening, inhumane conditions without sustained legal protections are unfortunately in place. And in addition, and this is important for our work, there are approximately 11,000 foreign terrorist fighters held in so-called makeshift prisons. These are buildings used as the prisons, but by no means they fulfill actually the quality benchmarks we have in ordinary prisons. The detainees have not been brought before courts. The detention largely lacks basis in fair legal proceedings, and this raised, of course, concerns under both international humanitarian law, but also international humanitarian rights law. The next slide, please. Here it is time to praise some of the work conducted by the Iraqi government. After a very thorough vetting procedure, they moved thousands of Iraqi citizens actually from Al-Hol camp now to Jeddah 1. And they started a very, very large repatriation action on northeastern Syrian soil. It was mentioned from Sofia that still 40 adults are in custody with a German association. 28 are German citizens in northeastern Syria. And I truly believe that our obligation to return people back from northeast Syria to Europe. This also goes for the many minors in the camps, because this could create stress in the future, also on European soil, if we forget these citizens. A 5 years old may ask in a couple of years why our government did not take care and repatriated us. So in the political arena, I'm always a strong advocate of the repatriation process, but I'm invited to talk about the reality in the German prison service. So please, the next slide. And again, everything starts with the law. This is a little snapshot actually on the legal framework in Germany. German terrorism-related law in the criminal code does not criminalize terrorism as a single offense, but use a mix of provisions against terrorist group formation, membership, support, financing, and related violent crimes. The German Code of Crime Against International Law is the German law that brings national criminal law in line with international criminal law, to put it in a nutshell. But here it's important to make a clear distinction. I represent the prison service. I did not work as a judge in the court. I'm not a prosecutor, and I do not work for the intelligence service. I work for the prison service, and therefore we have to look also at the specialized law for the German penal system. The next slide, please. Where we have namely the German Pre-Trial Detention Execution Act and the German Prison Act. Here I have to inform you that we have in 2006 a constitutional reform, and ever since then the federal state, the Länder, have a great deal of autonomy to draft SOPs and to regulate the insides in the prison. But for me, as a former prison practitioner and now policymaker, it's important to manage the expectations. I have now this Prison Act, and the German Prison Act, the German term is Strafvollzugsgesetz, is the law that governs the execution of prison sentences and certain liberty-depriving measures in Germany. Our citizens can expect from us that we execute, that we enforce this law. But I expect actually from my government that I'm able to do so, that I have the required resources to enforce this law. The next slide, please. Let's talk about practical work in prison in Germany. It was also mentioned by Sofia already. It starts quite often with pre-trial detention. When an individual is in pre-trial detention, the assumption of innocence applies. At this moment, we don't have actually the legal instrument to rehabilitate someone, because against the backdrop of the law, he or she is innocent. The purpose of pre-trial detention is not punishment itself. It's a safeguard to ensure that the criminal proceedings can work properly. This is sometimes a difficulty when we work with returned foreign terrorist fighters, because we miss this time of pre-trial detention in the sentencing period, because when an individual is in prison under pre-trial detention conditions, again, we are not enabled to work with him or her, and we miss this time quite often when we work with the individual on the rehabilitation. But once they are sentenced and the sentence is legally binding, we transfer also the FDFs then from the pre-trial detention center into the regular regime, in the regular custody institution. And then our work starts. Of course, during pre-trial detention, we make also briefly already an intake and assessment, but this is more about the individual biographical data. Once an individual is sentenced, we are legally obliged to establish within 3 months an individual prisoner rehabilitation plan. And this plan has to be done from specialized staff. So we need psychologists, perhaps social workers, criminologists, and they are the pen holders for an individual rehabilitation plan. The next slide, please. All right. In this individual rehabilitation plan, we have actually a very, very clear catalog of measures which we believe are the right ones to support the individual to serve the purpose of the sentence. We learned that the individual rehabilitation plan outlines measures the prisoner needs in order to achieve the enforcement objectives, but who knows what exactly the enforcement objective is? The next slide, please. And here I'm again back to the law. It's pretty easy, you will find it in the German Prison Act. The purpose of imprisonment is to enable prisoners to lead social responsible lives without committing further crimes and to protect the general public from further crimes. This is actually the mandate of the prison service, and it's, so to say, non-discriminatory. It did not make a distinction about someone who is accused for murder or sentenced for a petty crime or a return for interest fighters. Actually, we, the prison service, we have a clear mandate, and this is stipulated in Article 2 of our Prison Act. The next slide, please. Not being naive. How can we help individuals to live a law-abiding life? We have to start with structured rehabilitation measures. And there are various measures available in the prison system. But every prisoner has an individual rehabilitation plan. We try to shed light on the individual criminogenic needs. What is the need of an offender to be rehabilitated, to live a law-abiding life? And once we have conducted the diagnosis, in best case, we have a clear picture of the individual criminogenic needs, and then this is written and stipulated in the prisoner rehabilitation plan, and we have to execute it. We have to work then with the returnees. The next slide, please. I will not start PowerPoint karaoke, but here you have a list, actually, on measures which have to be available in the prison. They have to be available because this is stipulated in the law. I mentioned earlier that the civil society is expecting from me that I enforce the law. And to enforce that, I need this kind of measures. And this is, of course, you can imagine, linked also to resources. I need staff and I need money in order to support individuals towards living a law-abiding life with those measures. Education, vocational qualifications programs, occupational therapy, work-related training activities, but also access to psychiatric treatment services. It varies. Every individual have different needs. You mentioned it earlier, Sofia. Returnees are not that different. And this is true. These are individuals. They were in conflict with the law. They are sentenced. They are now for a period in our institutions. And it's on us to find the right measures to support the individual to live in the future law-abiding life. In theory, it sounds simple. In practice, it's of course challenging, and I'm not naive. It did not work out always, but we should be also confident because we have a quite good track record in rehabilitating individuals, no matter what they did. The next slide, please. External actors. They were mentioned. A lack of long-term funding was mentioned. And sometimes there's a question, why do we need external actors? There's a land map. I represent Bremen here. We work with VAIA, for instance. We work also with others, with Legato. And we made a very informed decision when we were confronted with the phenomenon of violent extremism in prison and the topic of radicalization at large. We made a very informed decision. We said, now we have a situation where we need support. We have many tools on board, but at the very beginning, we were somehow overwhelmed with this topic, and we said there are external actors who perhaps have knowledge we miss in that moment. Again, our task is rehabilitation. We have many tools on board, but at this moment, it was pretty clear for us that we have to join hands also with others who could provide assistant services. Long-term funding indeed is an issue. The political landscape changes sometimes, and perhaps you are in some federal states one election away from trying out having no more funds to do this important work. This is, of course, a pity, but on the other side, and this is actually where senior management comes into play, it's important to organize a good seamless transition between external actors and internal actors. What we did in Bremen was that we really early invited our management staff from the prison and these external actors to get familiar with each other. We provided external actors with a kind of internship in prison. We developed a small curriculum to train external actors on how to behave in prison. Because I also witnessed it myself, that a 22 years old graduate from social science entered a prison, says, hello, I'm Heidi, or hello, I'm Hans, and now I'm here to explain you how to rehabilitate challenging people. And this did not fly well. And it's our responsibility as senior leaders to explain our staff in prison. They have a great deal of self-esteem and confidence, why these external resources helpful. This is our obligation. And on the other side, we have also to explain external actors what we expect from them, where are the boundaries, where are the limits, but where we need them. The next slide, please. And why we need these external actors? Because reintegration takes place outside the prison. We have a very clear mandate. I make again the linkage to the Prison Act. We are in charge for rehabilitation inside the prison, but our mandate ends. And therefore, we have to seek alliance with resources outside, could be NGOs, could be others. And this kind of participatory approach is always better, because we need, at the end, the society to give space for people released from prison. This goes for every prisoner, not only for returnees. In Germany, we had the very, very comprehensive criminal justice reform in the 1970 years. In the spirit of the 1970s, there was an opening to convince also parts of the civil society that rehabilitation can work and that it's a good investment, that actually good prison work is crime prevention. And when we work with returnees, the same principles apply. We in prison, we work with them, we try to figure out what are the individual needs. We prepare the rehabilitation plan. We follow up with the rehabilitation plan. By the way, accordingly to the law, this rehabilitation plan has to be renewed every 6 months. So we measure progress. And the individual, of course, he or she has to do their part as well. We don't have a silver bullet, but we have a strong track record on rehabilitation. But again, reintegration takes place outside, and this is no longer our mandate. Therefore, it's extremely important to seek alliance with external actors, but also under clear conditions, let them know what we expect from them. Why multi-agency cooperation matters was now explained in greater detail. The next slide, please. Again, no single authority holds all relevant information when it comes to multi-agency cooperation. Security, rehabilitation, integration shall align. This is self-explanatory. And we have to ensure continuity. Prison release, the release will take place in the community. And this approach is, of course, extremely important. Put yourself into the shoes of someone who is in prison, let's say for 5 years, who has always the same contact persons, who knows where to seek assistance. There's a social worker, there's a correctional officer, there's even an imam in the prison. But once the big prison door swings open, you are left alone, or even better, when the community cares, you find your place. And I'm also a firm believer that the state can't do everything. At the end, we are actually a society of 83 million individuals, and everyone could play a role in order to maintain our social fabric that we can live in peace together. So the society at large should be engaged, in my humble opinion. There's always one dark cloud in the room. The next slide, please, when we talk about multi-agency cooperation. This was mentioned from Mr. Schindler. You know, we have soon Christmas. Everyone in our family has this uncle or this aunt we don't like to invite for the Christmas lunch. The same goes with GDPR. No one like to talk about GDPR, because you hear always from so many different partners, well, we don't receive information. We don't receive information from the prison services, what NGOs say. We don't receive the information from the probation services, what the prison service says. And the domestic intelligence is complaining that they don't receive anything from us. And for a quite long time, this argument was unfortunately true. We worked in data silos, and there were legal bottlenecks which prevented us from sharing information with other stakeholders. The next slide, please. But there's, my humble opinion, a solution. In Germany, we have now, or in Bremen to be specific, we have now the Bremen Prison Data Protection Regulation Law, which is a kind of catalog and makes it very, very handy for our practitioners to understand under which circumstances we are legally allowed to share information with other stakeholders. And this is all framed into the EU Directive 2016-680. This was actually the starting point who caused some hiccups in the German GDPR landscape when this was endorsed. Nowadays, it is, at least in my jurisdiction in Bremen, very, very clear what kind of information can be shared from, let's say, a social worker with a representative from an NGO who is involved in the individual disengagement process. This topic would need an entire seminar, but if you have more questions on that, please feel free to reach out. The next slide, please. As mentioned earlier, I represent the prison service in Bremen. The prison service, even in Germany, is very diverse. We have roughly 170 prisons. We have space to accommodate 72,000 prisoners. We have 16 different federal states. When you look beyond the border in Europe, or even beyond that, you will find actually different structural issues, problems, and challenges, but also opportunities. I put that together in this picture. The dark cloud represents systematic barriers we face in perhaps Germany as well, in Europe and beyond. Not enough staff. This is what you can hear everywhere. The foundation even made a very, very good research actually on the budget spend in the different lenders. Thank you very much for that. This was published recently. And of course, some federal states invest less, some invest more. And everything starts again with the law. If I, as a practitioner or policymaker, are requested actually to enforce the law, I need means, I need staff, and I need resources. How well is the staff educated? When we look into Europe, we find some jurisdictions where the training for a correctional officer lasts 240 hours. In other jurisdictions, the training to become a correctional officer lasts 2 years, like in Germany. Sometimes correctional officers, the uniformed staff, are a resource not well used in the individual disengagement process, but they are always on duty. They are 24/7 in prison. They are there in the night shift and on weekends. Our highly professionalized specialists are quite often only in the prison from a 9-to-5 pattern. Weak infrastructure. I talked about the makeshift prisons in northeastern Syria. They are by no means something which we could identify as a prison in Germany. Punitive societies play a role. This is, of course, a long-term goal, but practitioners and other people, they shall really raise voices in order to advocate for the importance of rehabilitation. Lack of political will. The topic is not sexy. Let's say it loud and clear, of course. If I would run a rally to become a president, I would also perhaps choose different topics. But if we are serious about what we are doing in our societies, we shall respect the rule of law, and one integral part in our security architecture are prisons. And then we have to invest in that. The future after release is very close linked, of course, to punitive societies and the public opinion. Unhealthy prison environments are actually an accelerator for radicalization in prison. We had, and I say this with pride, less cases of radicalization in prison because I believe we provide, in general, healthy prison conditions. And in some other countries who have more structural challenges, the likelihood of individual radicalization may be higher. So what we have to provide is rehabilitation with the goal to reintegrate these individuals, because 90% of the prisoners will be released one day and they will be among us. Some countries say the prisoner of today is the neighbor of tomorrow, and therefore we have to invest. This goes for all, but also for returnees. Sufficient staff is important. Take more focus on CBT, cognitive behavioral therapies are extremely important. As was mentioned from Sofia also, that there are sometimes programs lacking for this particular group of prisoners. We should pay more attention to that. We should use multi-agency cooperation in the frameworks of our legal framework. It is not that we are prevented from sharing information, but we have to do it in the right way. Psychosocial support and good order and control and prison intelligence. These topics go, in my opinion, hand in hand. We need solid infrastructure. We need different kind of security. We need dynamic security, but also procedural and structural security in our prison. So even when we have challenges in front of us, no one told us it will be easy, but this is quite usual when you work in prison. The next slide, please. I thank you very much for your attention. I tried to encapsulate everything in 20 minutes, which I managed somehow, and I give now the floor back to you. Thank you.